Hello, welcome to Civic Conversations. I am your host, Marvin King. Over the last several years, there has been a dizzying array of reforms to the college sports landscape that might have considerable Title IX implications. To help us better understand these changes and challenges is Erin Buzuvis, professor of law at Western New England School of Law and associate dean for academic affairs. Dean Buzuvis's research and teaching focuses on sports law and gender and discrimination in education and athletics, among her many specialties. Erin, welcome to the show.
Thank you for having me.
In terms of collegiate sports, what would you say is the major consequence of Title IX?
Title IX, notwithstanding its original intention focusing on classroom equity and employment equity in higher ed, really made a dramatic change in collegiate sports by increasing the number of athletic opportunities available for women. Just for some contextual statistics here, prior to Title IX in 1972, the number of athletic opportunities for female college students was in the order of 30,000. And today, NCAA opportunities alone are 230,000. So a dramatic spike in the number of athletic opportunities. I think that is both a cause and effect of other consequences of Title IX in terms of its impact on the culture. I think one of the reasons why Title IX's effect has been so dramatic is because it had a normalizing effect on women's participation in sports. In the details of the regulations that were eventually promulgated by the Department of Education's predecessor agency, in terms of telling colleges and universities that an expectation of equity, an expectation of shared resources now exists under the law. It really gave female college students and their advocates the reason to believe that they were entitled to fairness, that they were entitled to equal treatment under the law. And that has pervaded, I think, the cultural ethos. We expect women to participate in sports. We don't disparage female athleticism the way we did prior to Title IX. So I want to emphasize both the quantity and the nature of that impact being in the culture as much as in the law. Yeah.
Specific to athletics, would you say that Title IX has fixed the problems it was intended to resolve? Is there still outstanding issues? How would we rate kind of the success so far of Title IX as it applies to athletics?
So that's the other side of the coin, right? Title IX has inspired astronomical growth in women's athletic opportunities. But Title IX wasn't intended to do that. Title IX wasn't intended to grow women's sports, to take it from point A to point B. Title IX, as the regulators attempted to create a framework that would apply it to athletics, that intention was to have equity between men's athletics and women's athletics. So, in some sense, the problem that Title IX was intended to fix was that men had more than women, not that women didn't have a lot. So maybe Title IX regulators would have been satisfied in a world where athletic participation rates remained low, but similar. That's not what's happened. Athletic participation rates have grown for women, but they have grown for men even more. So the disparity that Title IX framers intended to resolve has not dissipated, it has exacerbated. Um, some data along those lines for context. A recent report by the Government Accountability Office found that at 63% of colleges, women's athletic participation was at least 10 percentage points lower than their enrollment rate. And that's one of the important measures for equity in terms of the distribution of athletic opportunities. If you've got a college student population that is, say, 55% female, then a proportionate distribution of athletic opportunities would mean that women get 40 would get the same percentage of athletic opportunities, get 55% of the athletic opportunities. And what this data is saying is that mostly women aren't even getting not even within a 10 percentage point gap of the percentage that they of their enrollment rates in colleges. So if you're at something like 55% women in your student athletic population, only 45% of your athletic opportunities would be women. So that is the case at a majority of American colleges. If you quantify that in terms of numbers, you'd have to add over 200,000 athletic opportunities for women. And remember when I told you above, women's athletic participation rates in college is about that already right now. We'd have to double it in order to close the gap. So there really are astronomical disparities that have persisted. Notwithstanding Title IX's equity mandate. And this is not just in terms of numbers, but in terms of the quality of opportunities as well. There's a resource gap, there's a scholarship disparity that go along with that as well.
You see some universities add sports programs that have large numbers like crew, where you might have 50 or 60 women on a team, but that's relatively rare. And it seems that some of this is a reflection of the fact that higher education enrollment trends have changed so much over the last 20 and 30 years, where you just see more women matriculating into universities than men, which creates its own separate issues and problems for society. It seems that athletics have not kept up with the changing demographic profile of university higher ed enrollment as a whole, if I'm understanding
Yeah.
those numbers correctly.
Yes, yeah, not keeping pace with enrollment as a whole is definitely, I think, if we're looking for some root causes here, that would be one. A partial explanation for these persisting disparities, the limitations in the law in terms of enforcement. Because Title IX, it's a statute that is fleshed out by regulations, and those regulations are overseen by an administrative agency, the Department of Education's Office for Civil Rights. The Office for Civil Rights has exactly one tool that they can use if they don't like what a university is doing, and they can cancel their federal funding. That is proven to be historically a hammer that is too big to use. It's not really a good fit as a remedy for this problem because it ends up punishing members of the university community, i.e., students. Usually, it's students' federal financial aid, right? Not even having anything to do with athletics, which is the source of federal funding, over mistakes or inequitable policies that the university has persisted. So it punishes the wrong people. It can be a very severe and disproportionately large punishment. So as a result, we don't see that actually happening in most cases. Instead, when there's a report of a disparity or a problem, somebody takes the initiative to point it out to the Department of Ed. They'll show up, they'll do an investigation. If they find, yeah, this is a problem, they'll tell the university at that point, well, finger wag, you should fix this going forward. And they do. But if you don't have to solve a problem until the Department of Education shows up at your door, why would you do it in advance? Why would you do it early? So I think this is part of the explanation for how colleges and universities kind of kept kicking the can down the road in terms of letting their athletic opportunities for women catch up to equal before continuing to grow opportunities for men. And now they say, oh, we need to keep these opportunities for men and we need to grow them because of that enrollment disparity. The only way we're going to get men to come to college is to lure them with athletic opportunities. And so, a problem of their own making, the claim is that the solution is to make that problem even worse.
Well, I think kicking the can down the road might be the title of your next book or article, in
Try.
in
Yeah.
explaining some of these issues. Let me ask you this. I had a prior speaker come on and talk about the House settlement and NIL. So regular listeners and hopefully students who are listening to this have listened to those. So moving forward, what might be the Title IX implications because of the introduction of NIL and the House settlement that we might see over the next several years?
The impact has the potential to be dramatic if universities continue to employ this approach of evading compliance. Um, Here are some of the things that could go wrong, right? So, NIL compensation. First, we should differentiate, as the law would, between NIL compensation that an athlete would receive from a, a completely separate entity, a third party, someone not connected to the university who's paying them for reasons that are not connected to the university.
So we're not
So,
using state money, anything like that,
right,
presumably?
right. If we're talking
Okay.
about a major apparel company, or a sports drink company that wants to have a commercial or a billboard featuring college athletes and goes out and taps some of the highest profile college athletes to appear in that billboard or to appear in that ad. That's a financial relationship between this company and the athlete that the university is not in the middle of. The university isn't benefiting from that. Uh, I would say that the student is being compensated for their name, image, and likeness because of who they are, not because of who they play for. And in those cases, if that's truly the case, that this is separate from the student's relationship with the university, then Title IX would not have any reason to apply, because Title IX applies to how a federally funded university is spending its money on its athletes. The other side of the spectrum, where it's very clear that a university is playing a role here, is if the university is directly compensating athletes, a sort of pay for play situation. And then in the middle, there might be some gray area where an affiliate of the university, not the university itself, is paying the student athlete in a way that may or may not on its face appear to be pay for play, but might actually be pay for play underneath, right? So you've got a local business, maybe it's a car dealership, and the owner is an alum, and the owner knows that, "Hey, if I offer a NIL deal to this prospective recruit, that might sweeten the deal and get this athlete to come, and it would be less that the university budget would have to do to try to get that athlete to come," right? So then that looks like there's some kind of coordination or some kind of affiliation. So in the case of where the university is doing direct compensation or where there's a university affiliate doing compensation in ways that appear to be effectively pay for play, um, the argument that I make is that Title IX should clearly apply in those situations. Um, it is not, though, something that is directly written in the law itself. The regulations do not say that that salary or, compensation or stipend or whatever it may be is something that is subject to the Title IX equity framework. Why not? Because those regs were written in 1975, and it has only been very recently that the idea of this kind of compensation has even been on the table, right? For so much of American history, the NCAA had a tight lid on that kind of compensation and prohibited. So there would have been no reason for regulators to put it in the Title IX framework in black and white. But what the Title IX framework does talk about in more general terms is equal treatment in all of the ways that athletic departments are supporting their athletes. Anything that an athletic department is doing for their athletes, whether it's the quality of the coaching they provide, the quality of the meals that they provide, whether you're being transported to your games in a chartered plane, or you have to drive yourself. Any of those kinds of features of like the college athlete experience are supposed to be equalized. And to say somehow that compensation would not be included on that list, even though it's not enumerated, but would effectively be included by the fact that that list says and others, right, other things, essentially leaving that door open for things that the regulators hadn't yet thought of because they didn't exist yet. So I think there's a clear connection to the reg, even though that language isn't stated in there. What would be very helpful would be if the Department of Education today said in no uncertain terms that that's the case, because that is something that might catch colleges and universities' attention. And that is not yet a clear message that we're getting from the government.
You've answered one of my next questions, which was, has the law kept pace with the economic changes in college athletics? It sounds like the answer is no. And then what recommendations or changes would you make into the statute? And maybe it's the statute, but also how the Department of Education then interprets the statute in terms of guidance that it provides to universities. You've also made me think of, I feel like I should do another episode and get someone to talk about whistleblowers, because I feel like there are probably a ton of great whistleblower stories out there in terms of the differential treatment between women's and men's athletic teams, especially in terms of their, as you say, their accommodations, their travel. Today's guest is Erin Buzuvis, professor of law at Western New England School of Law. And you may have heard that the University of Arkansas is shutting down both their men's and women's tennis teams for financial reasons. We are recording this on Monday, April 27th, 2026, and this news came out just late last week. Inevitably, whenever a college athletics program shut down, critics of Title IX will blame that law for a program's demise. So, what is your response to that critique? And do you think that criticism might have more or less weight in this current financial landscape that we're in now?
Yeah. So the as best I can tell based on publicly available and reported data, which I'll admit lags a couple of years behind reality. So I'm doing my best with the public data that we have. But it appears to be the case that of about the 600 athletic opportunities that the University of Arkansas makes available, only 47% of those go to women, notwithstanding the fact that women are almost 56% of the student body. So here's one of those universities like I was talking about at the beginning, where the disparity looks like 9 percentage points. That's a pretty substantial disparity. Uh, and that is not something that happened by accident. That's not something that happened overnight where the University of Arkansas woke up to an enrollment that was predominantly female. That's gradual, and that has been the case for now a long time. So if the disparity exists that women are in the position of having the majority of the student enrollment population and the minority of athletic opportunities, the way the law works is that if they sue, they'll win. They'll win. The men won't, and the women will, because the university cannot likely show compliance now with any of the 3 alternative ways that you can demonstrate compliance, and one is proportionality. We've already explained why that's not there because of this 9 percentage point disparity. And that when you cut 2 teams, you're not changing the disparity, you're just bringing everybody down the same notch. And so the other 2 opportunities, the second prong for Title IX compliance is you could, if you show that you're consistently adding women's athletic opportunities over time and you just haven't quite reached, the end point yet of proportionality. No, that's not the case. If you're cutting women's teams, that's the exact opposite of a continued expansion, which would be the second test. And then just to round out the all 3 tests so I can back off of this subject. The third one is that there's no unmet interest among the underrepresented sex. Women are the underrepresented sex, and when you cut a team, you now have automatically created unmet interest. So I would think that they've lawyered up. If they haven't yet, they should, and that would be a likely successful case to get their team reinstated. There have been dozens of these cases in the last few years, cutting men's and women's teams together. The women sue, the women win. I don't know why colleges and universities keep doing this. That's my take on the University of Arkansas, that this is not a very legally viable position.
It seems that universities have to be making a good faith effort to reduce that, even if it takes a long time. But these trends in higher ed enrollment are decades in the making now. So universities likewise have had decades to become compliant. And if they still haven't, or if that ratio is actually getting worse, then it does not seem like a strong legal argument for Arkansas. Presumably their lawyers have already thought about all of this, but your point is that they usually lose in this situation. I think you've given me a nice project for some of my students to go look up some of these cases and, write a little study about it.
Yeah. Yeah, and, so you'll find a bunch in recent years because, the COVID era was a moment where kind of simultaneously across the nation, higher ed resources were constrained, and when resources are constrained, athletic departments are under pressure to cut teams, and they like to do this because of the optics. We're not taking this out on men or women, we're taking everybody down together without considering the context, which is that women are already the side with less. So, there were a number of these cases in the sort of fallout from COVID, kind of a cluster, right? And I and you asked about whether this could be connected in any way to the NIL House era. And I think that this has the potential to be another one of these clusters because not because resources are constrained necessarily, but because colleges and universities are simultaneously deciding for the same reasons that their resources need to be concentrated in sports other than sports that are like tennis that have less potential for revenue.
Less potential for revenue, but more gender diversity. And this is just a classic example of where the law does not match the reality of college economics, but also equal protection is equal protection. And the framers of equal protection weren't thinking about college athletics, they were thinking equal protection. And that has to be in my view, and correct me if I'm wrong, but it seems like this is how the courts have interpreted it: is equal protection is equal protection. Your economic reality is something you can amend, um, but schools have chosen to double down on sports that have 85 man rosters, like football, and so that's going to create a great disparity.
Yeah. Right. Because they're chasing profits. And, they may get profits, maybe they'll get revenue, maybe that'll be enough revenue to translate into profits. And I think your point about equal protection is equal protection. Yes, when Congress passed Title IX, what it was saying is that education in general, including higher education, is an aspect of society where equality and equal treatment matters more than commercial outcomes. It matters. It is not just a place where if it where we can let free market decision making run unconstrained if that lack of constraints is gonna lead to disparities that offend our notions of fairness and equality, because it's education is important. So when people say, "Well, colleges and universities should be able to do whatever they want to pay athletes because of the free market," Um, to that I say, "No, we've already decided that the free market has constraints because this is education. If you want to run a professional league outside of the context of education, go ahead, and you won't have Title IX constraints. You can do so without having to worry about gender equity. But if you're gonna do it in the context of education, which is for some reason, we're the only country that seems to have this marriage of higher education and massive athletic infrastructure, that's fine. But if you're gonna do it, you have to do it then within the constraints that come with higher ed. And one of those is a fairness mandate, an equity mandate, and you have to make sure that women are getting their fair share.
You've helped bring a lot of wonderful context to the law. And in Mississippi, where I am, college athletics is king. We do not have any pro sports. So what happens at University of Mississippi, Southern Miss, Mississippi State in particular, really drive the discussion about athletics in the state. And so there's a lot of interest in this. In college athletics, it's not just the free market. To your point, we are not the minor leagues, we're not the professional leagues, so we've got the constraints. I couldn't imagine any parent in the state how they would react if a K through 12 school said, "We're going to eliminate half of the women's sports because we spend all of our money on football. So we're going to have football, men's basketball, and we're not going to have women's sports because we just can't afford it." People would be up in arms. And you're telling us that college is essentially the same context. Uh, do you have a book or an article that you would like to recommend for listeners of today's episode who want to learn more and dig a little deeper on the subject?
Two resources that are great for a general audience, not necessarily law professor wonky articles, but good for the intelligent reader of any from any background or discipline. I think that there's a law professor named Deborah Brake, whose body of work I admire in full, but she's written a book called Getting in the Game that really translates a lot of this legal nuance to a compelling story about the history of our statute, Title IX, that is accessible to experts from any background or field. I also think that the Women's Sports Foundation, their resource file is rich with reports and information about a range of related topics, but they did one on the 50th anniversary of Title IX called 50 Years of Title IX, We're Not Done Yet. If you want to dig deeper into the details of the law's application um, well, in the athletic context, across a range of issues, all kinds of intersectionality between gender and race, for example, or a Title IX's application to LGBTQ rights, looking at a variety of resources, not just participation opportunities, but scholarships and other manners of resources, looking at both high school and college. I think that's a great report that could also take the reader into a reader who wanted to read the footnotes could also find other sources to then follow up on.
Thank you for those suggestions. We will include those in the show notes. So, once again, I'd like to thank my guest, Erin Buzuvis from the Western New England College of Law. Thank you for your time today.
My pleasure. Thank you, Marvin.